Hello class, my name is Joseph Maurer, and this is my presentation on the case Roe v. Wade. Firstly, the background. Two lawyers named Sarah Weddington and Linda Coffey fight anti-abortion laws in the US. This is a very hard thing to do in these times because it's the late 60s and pushing for women's rights, especially through the legal system, seems impossible. Fortunately though, they think they have an opening to where they can actually win a case like this. Alright, Linda. So in the state of Texas, there's a judge who is sympathetic to our cause, Sarah Hughes. Now all we need is a plaintiff who could represent us in the state of Texas, and this case is ours. But that seems very specific now, doesn't it? We would need a Dallas resident who is pregnant, white, of low income, young, and willing to get an abortion. Now, that just seems impossible now, does it? Luckily though, in June of 1969, Norma McCorvey fits all their criteria when she becomes pregnant with her third child. See, she's unmarried and single, so getting abortion is kind of forced for her as she cannot financially support the child because, she's of low income and no one else can help her out. So she seeks out her doctor who says, no, sorry, under Texas law, you cannot get an abortion. But this isn't the end of her trials, though. She also allegedly falsely claims to be raped in order to get an abortion and try to get an abortion through an illegal clinic. These both don't work, and the clinic closes down before she could even do anything. So all hope is lost, right? That is what you would assume until our lawyers show up and say, "Hey, you, how would you like to get an abortion?" Eventually, through the legal system. And this is how Norma McCorvey became Roe, one of the most significant legal figures of our time. In the U.S. District Court, Goldberg, Taylor, and Hughes are the judges of the case, as Roe faced off against Henry Wade, who was the primary enforcer of the Texas statutes. So yeah, it makes sense that he's the one who wants them to stay in place. But unfortunately for him, in a unanimous decision, they all rule in favor of Roe, stating the statutes as unconstitutional. But they also decline an injunction to deny these statutes, so they're basically still in effect. So Wade goes, hey, I'm still going to enforce these laws, so it's like nothing changed. Ooh, what are you going to do about it? Then Weddington goes, appeal to the Supreme Court maybe? Then Wade goes, well, I'm also going to appeal it because I think my statutes are constitutional, therefore this shouldn't even happened in the first place. And that's basically it. Here is all of that, but just the primary details. So if you want to take notes, do so now. Okay, now we move on to the Supreme Court. Firstly, the constitutional questions. Firstly, does outlawing abortions infringe on a woman's right to privacy outlined by the 14th Amendment's Due Process Clause? And is the right to an abortion a fundamental right that is not specifically enumerated by the Ninth Amendment? Well, after the case got appealed, postponed, leaked, re-argued, and then leaked the day before, the case was decided. And in a 7-2 vote, Roe won and Wade lost again. And now, for good, the statutes were determined unconstitutional and not in effect. The majority opinion given by Blackmun and these guys stated, the Supreme Court ruled that states do not have the right to deny a woman's right to control her own pregnancy and body at the beginning of a pregnancy because of the 14th Amendment's Due Process Clause, which states that no life shall deprive any person of life, liberty, or property without the due process of the law. The Supreme Court also ruled in favor of the fact that the right to privacy included the abortion decision so that states could not ban the abortion in the first place. What about the dissenting opinion? Well, the two judges, Reinsch and White, argued that privacy under the 4th and 9th Amendment did not include abortion, since banning abortions did not implicate fundamental rights. In order to be protected by the 9th Amendment, you need some rational basis like protecting the fetus instead of aborting it. This actually comes up later in the Dobbs case, but that's far down the line. Alright, now this is everything after. Impact on society. It was taken pretty hard when it first got released, but Roe v. Wade caused a 4.5% decline in births in states that had not previously legalized abortion. It also increased the working force of fertile aged women, but decreased the working force of older women. This happened because, well, fertile aged women could give birth, but if they didn't want a child, they could abort it and stay in the workforce. But older women didn't really have to, be in the workforce anymore because they didn't have as many children to support. So once they could retire at an earlier age. This also ties in a little bit with the legalized abortion and crime effect theory that that abortion also affect the crime rate because women who didn't want children but were forced to probably didn't take the best care of them or maybe even left them to the streets. So more parents who actually wanted their children actually took care of them. Though even though this had big impact on society, it was overturned partly by Planned Parenthood v. Casey in 1992, which actually strengthened abortion rights, but it was fully overturned by Dobbs v. Jackson, Women's Health, in 2022, which is a current day political topic now. And it completely nullified Roe v. Wade. It's not in effect anymore, which is why you don't really have to know this for the AP test. But now it's time for the fun facts. Alright. Norma Corey's third child, Shelley Lynn Thornton, was born on June 3rd of 1970. This was only 15 days before the district court decision was given. So what happened to her? Well, 3 days after she was born, she was just put up for adoption in Texas, and she didn't even know she was a part of this whole Roe v. Wade thing until like she turned 18. She never really reconnected with her mom because, she didn't even want her in the first place, and she's not pro-life or choice, so that's how she stands. And this is pretty interesting. In defense of Wade, attorney Jay Floyd made what is known as the worst joke in legal history in his opening argument. And here it is. Mr. Chief Justice, and may it please the court, it's an old joke, but when a man argues against two beautiful ladies like this, they're going to have the last word. Apparently, due to a witness, we know that this joke was not well recepted. In fact, it was met with dead silence in the court. It was also shown that Chief Justice Berger was glaring eyes at Jay Floyd when he made this joke. So he was pretty mad, and rightfully so, because, this isn't really the sort of joke you want to make when this is a landmark case of the United States about women's rights. But, who cares? When the Supreme Court took up Roe v. Wade, Weddington did not speak to McCorvey until 4 months after the case was decided. See, this is because of Norma's previous actions before Weddington even met with her. By, she did illegal drugs to relieve the stress from her not being able to get an abortion, as well as falsely claiming to be raped and trying to get an illegal abortion. Those would not look good in court. So, trust me, they wanted Roe to be very, very far away from McCorvey because, you don't want that person representing women's rights as a whole. They want it to be as plain as possible about Roe not being one person, but representing all of women who needed an abortion. And also, Roe v. Wade was issued alongside Doe v. Bolton, which is a very similar case. The only main difference is that Doe's case was in Georgia, Roe's was in Texas, and Doe's was about rape, and Roe's was about the health of a woman. So yeah, that's it. Though all of what we talked about right now doesn't even matter anymore because of, Dobbs' case. So yeah, take this information as you will, and yep, bye.